Nice. We're live. All right. Cool. Awesome.
Yay.
So, yeah, I'm Amir, a DV with the DVIP Group. We're intellectual property attorneys based here in San Francisco, California. And we have our lovely guest here today. I'll let her introduce herself, and we're just going to talk about IP and however our conversation goes. It'll be a good one, no matter what.
Yeah, definitely. Hi, and welcome to this live stream.
Do you want to start out by telling us where you live, where you work, what you do?
Yeah, of course. So I live in the island of Puerto Rico. My my license is not from Puerto Rico, it's from New York because I have a really long and interesting story of being a nomad. So I've been places. And I specialize on intellectual property, most specifically trademarks and copyrights. But patents I leave to you.
So you said nomad. Nomad. What do you mean by that? Why?
Well, I was born and raised here in Puerto Rico. I did my bachelor's and Juris Doctor here in the University of Puerto Rico, where I'm working right now.
You're a professor there, right? Clinical?
Yeah, I'm professor here and also coordinator of the Masters in Law and international programs.
Wow. Do you have a good blend of teaching and administration, or is it more administration than teaching, or is it a good balance?
It's sometimes it's more administrative and than classes, but sometimes it's more balanced, where I get to have like a good full day where I can focus on, let me update my class or let me do this exercise and that sort of thing.
Oh,
But with the nomad thing, I finished my studies. I left the island in 2016 to study for the New York bar exam. So I was in New York for a while. Then I got accepted to UC Berkeley, so I left for California. I finished that and then ended
I
up
never I
in
never had the opportunity to meet you when you were out here, which is unfortunate.
yeah, which is unfortunate. Like you were right there, but things happen. Life happens. And then I ended up in Indiana, in Bloomington, Indiana.
Was this
To
pre-COVID when you were in Berkeley or New York?
Yeah, this was all pre-COVID. I was in COVID in Indiana.
Oh, wow. Okay.
Yeah,
In Bloomington?
in Bloomington for my SJD.
Oh, wonderful, wonderful. So you have a Juris Doctorate.
Yeah, I have a JD and a doctorate in judicial science, which is kind of like a PhD in law.
Wow, that's really cool. Yeah. So what was that transition like for you, going from East Coast, West Coast, and then Indiana?
It, it's so different because New York is like way too much things happening all at the same time, and then California is all like very hippie, very like upbeat, very youthful, and then Indiana's like this small cozy town, like your stereotypical Hallmark movie.
Yeah. So when you were in New York, that was your JD, or was that your or that
No,
was just
just
to take the.
just to study for the bar.
Oh, I see. I see. Okay.
Yeah,
Okay.
yeah.
All right.
The JD was in Puerto Rico.
I see. Okay. Okay. And is that where you grew up?
Yeah, yeah.
Oh, wonderful. Wonderful. Okay. So then you went to Berkeley for your, would it be LLM?
Yeah, for
Oh,
the LLM.
okay. And is that because I actually have an LLM that I don't use very much, but I have an LLM in taxation.
Oh, really?
They're very, very different. Though there are interesting tax issues in IP. But yeah, so it was your LLM in like comparative law or?
No, it wasn't IP.
Oh, of course. Yeah. Okay.
The only odd man in the group is my bachelor's, which is accounting and human resources.
Okay.
But
Okay.
I use it on the daily for IP, which is kind of like your taxes.
Right. Yeah. Makes sense. Makes
Yeah.
And then when your SJD, was that also in IP? I see.
Yes. Yeah, my dissertation was focused on a local law here in Puerto Rico that is a trademark to certify agricultural products, but
Oh,
its good intentions left a lot of legal questions and vagueness that it doesn't work efficiently. And it has so much potential that if you configure it correctly in the public legislative point of view, that it could become a geographical indication.
oh.
Yeah.
So this is a trademark through and valid and enforceable in Puerto Rico, and it's
Yeah, yeah, it still
for
lives to this
agriculture.
day. Yeah.
For agriculture. Okay, okay. But is this recent legislation or is this old? Sorry, I'm not familiar
It's
with it.
it's fairly recent. It's 2016, but the
Oh,
trademark has been in existence since 2002. But people who I've interviewed have argued that it's been in existence since 1964.
oh,
Yeah,
okay. So this sort
and
of
it's
codified what had already. I see. I see.
yeah, and it was trying to prevent emphasis on the quotation marks, trying to prevent the lack of uniformity that was going on with the marketing and with the changing names. And with the fact that the government did not know what to do with the farmers that were using that trademark, and the farmers didn't know what to do with that trademark.
Oh, I
Yeah,
see.
it didn't solve the issue, but it was, and that was the whole
But
gist of
that
it.
was the target. It was trying to create more harmony.
Yeah, it was trying to create more harmony.
I see. I see. So it's still a point of contention then, and I assume there's talks about possibly repealing or creating some new law that'll supersede, or
No, I think it's going to keep itself that way as it is. What what the political parties do is just like slap a new name on it and change the logo and think that they did this whole new innovative thing, but it's the same thing.
uh,
Um, they have tried to like derogate it or change it completely by adding international stuff. And what my I mean by that is like our local law in trademarks acknowledged the fact that the U.S. signed the Berne Convention for like moral rights, and
uh,
then came the visual arts one that like acknowledged moral rights for the U.S. But we were the first. So in that sense, the change in the law was trying to like say, oh, let's do the same thing, but with the Lisbon Agreement, which is for geographical indications. But they completely forgot the fact that the U.S. hasn't signed the Convention, so it's a no law.
oh,
Yeah,
that's fascinating. I can see how you could do a whole dissertation on this.
yeah, yeah, exactly. And there's other similar trademarks. Like there's one called Made in Puerto Rico. Obviously, it's in Spanish. It's called Hecho en Puerto Rico, and it's for services, manufacturing, and agriculture.
Oh,
The difference with this the Hecho en Puerto Rico and the one that I studied is the one that I study is exclusively for agriculture, and it requires that the whole supply chain has a 90% or more that to occur in the island, whereas Hecho en Puerto Rico is only 35% of the
45?
supply. It yeah, 35.
30, oh,
Of,
35, 35.
yeah, of the supply chain has to occur in the island.
So basically a third is the
Yeah.
idea. I see. And so what's the name of the mark again that you studied?
It's del país.
Oh, del país. Okay.
Yeah,
Okay. Okay. And that, you said 90%.
yeah.
Wow. Okay. Yeah, I'm sure there's a lot of interesting issues with what counts as on the island and
And
interesting.
what doesn't?
Yeah.
Yeah.
Is that a huge point of contention? It is.
Yeah, it's a huge point of contention because by default, 90% of the things that you see sold in the supermarkets are imported. That's why we had these such a big issue with Hurricane Maria.
I see. I see. Wow.
Yeah.
When you went back to Puerto Rico from, I assume you went from Indiana back to Puerto Rico. Was it to join the university?
No, it was to like figure stuff out. So I was like seeing what could happen. I got a job that didn't last very long, and in that time, I got the opportunity of the World Intellectual Property Organization. And I was like, yeah, sure, of course. And it was on the Department for Trademarks and Geographical Indications. So I was like, yeah, sure, okay, count me in. And now that I complete the internship, I get to implement my dissertation in real life with
Mm.
one of the clients that I kind of inherited.
Oh, that's cool.
Yeah.
Wow. How did you settle on focusing your dissertation on Del País? Was it something that you just always had an interest in, or?
Yeah, I always piqued my interest because I still talk about this in my social media, but back in the day, back in 2008, I began this whole social media journey with food blogging. So I wrote restaurant reviews and travel. I was very into food. I love food, and it was my escape from law. But I was like, there has to be a way where where my two loves can come together and make sense.
I'm thinking
And
like
how,
we got to hang out sometime. I like food too.
yeah, like my jam is it's a very stereotypical California food, but tacos and acai bowls and sushi.
Yeah, there you go. Nothing wrong
Yeah.
with that.
So with I was saying like there has to be a way that I can mix my two loves of food and intellectual property, and hence was born my dissertation.
So the is the idea that when items get exported, they want to be able to put that stamp and mark it with Del País, or is it more having to do with preserving the quality of food that was created in the actual island on the actual island?
It was for both.
For
So
both.
the short term goal was the quality aspect, and the long term goal was export.
I see. I see. This
Yeah,
is our brand. You want to
yeah,
buy Del País because you know it's delicious, good quality, high quality product that you're getting, and
yeah.
so it also helps. Obviously, there's a nationalist interest there, trying to promote Puerto Rico.
Hmm.
I see. I see. Okay. Huh.
Yeah, and it was really hard to get data because agricultural data in Puerto Rico doesn't exist. If it weren't for the federal agencies, we wouldn't have any data.
Hmm.
So trying to record anything about the economic development of how this trademark actually worked, if it was in fact helping the farmers, I had to conduct interviews and use social media to find information and compile different reports from different times because when you finally said, "Oh, I found data," it was politically biased.
Oh, of course. Yeah. So I'm sure your accounting background helped tremendously, right? Because in order to get to level of dissertation, doing original research, I mean, you actually have to collect and analyze data.
Hmm.
So I'm sure that was really invaluable to have that background.
Yeah, that was the time where I said, "Thank God I studied accounting," where I can notice where numbers are off.
Wow. Did you have some end thesis that you um, at the end of the of your research that that you thought was would be impactful? Was there did you come to any conclusions? I guess is what I'm wondering.
Yeah, yeah, my conclusions were a set of recommendations of
Oh wow.
public policy to implement and change the law completely overhaul it. So, like for instance, one of my major contributions is a system of requirements that instead of being the same set of requirements for everyone, it would be scaled
Oh,
depending on your company size. So
size.
the smaller you were, the easier it was to fulfill those requirements. But the higher up you were in the food chain, the harder it was. And it was because the incentives were going to be formulated in that same way. The smaller you were, the more incentives you were given
Yeah,
and the more help. But it was because I got those from taxing the larger ones, the larger companies.
I see. Well, I would also imagine if you're a large organization, you have a more complex supply chain, and so there'd also be more risks and more difficulties in trying to actually ensure that the quality actually is maintained, anyways. So, I mean, it makes logical sense.
Yeah, yeah, and also like you have to keep in mind that Puerto Rico is a tax haven, so
Uh,
large companies have it easy.
I see. I see. So you're thinking as well. Yeah, you have this slight extra burden, but you also don't pay taxes. So,
Yeah.
huh. And then it creates a revenue scheme also for the island. I
Yeah,
see.
yeah, and the smaller farmers were having such a hard time with complying with the requirements, and sometimes they were even scared off from using the trademark because then people started saying like, "Oh, if you use the trademark, they're gonna cut you off from SNAP, or your kids are gonna be taken away, or like,
Wow.
oh, you're gonna lose your home." So things that were completely unrelated to the use of the trademark, but the thing is that the use of the trademark was tied to the bona fide certification for farmers,
Oh,
and you received money. And they were like, "Oh, then if you have the bona fide certification, they're gonna take the rest of away from you."
I see. I see.
Yeah.
Wow. So right now, are you teaching? Do you get to teach other research students, or are you teaching core IP classes?
It's core IP. It's Introduction to IP or IP Survey. Then next semester, I'm gonna teach research and investigation for the LLMs.
I see. So you are getting to do research methods.
Yeah,
Yeah, yeah.
yeah.
I imagine that's a hugely valuable skill.
Yeah, yeah. I'm gonna get to have the liberty of professorship and be like, see this blue book, throw it in the trash. Nobody uses it after law school.
The infamous blue book.
Yeah, the infamous blue book. Use social media. Let's be on Reddit for like hours on end to look for literature.
Yeah, yeah, yeah. If you need to draft a good citation, just ask ChatGPT to do it for you.
Yeah, yeah, yeah.
It can
Get
spit
yourself
out.
in trouble.
Yeah, yeah. Yeah, how does your school respond to that? Because I'm affiliated with two schools, and it's interesting because I've noticed that they're doing what they can to educate and to embrace, because they know it's here, and so their attitude has been more, let's figure out how to equip our professors with more knowledge so that they at least have some basis and understanding for how they might either incorporate it, acknowledge it, or just let it live side by side with the institution of education. So, has that
Yeah,
been an issue for you guys?
we're trying to integrate it to different things. So, like for instance, trying to update our system um uh, for like choosing your classes,
Oh yeah,
for like grading and making professors' lives easier with that with the whole syllabus thing. But like there's a divide where the I've seen that the older professors are like, oh, we shouldn't be using that. Like students are getting lazy because of the use of that. But the younger ones are like, yeah, everyone uses it. There's no way in denying it. There's no way in escaping it. We should just like be cautious of how we use it because it's a double-edged sword, where like, yeah, it could help you, but it can also cause infringement.
Exactly. Yeah. Yeah. I've been viewing it more as just like another resource, another
Definitely.
tool. Yeah. It's like you do your Google searching. Okay. Have you Googled it? Now it's, have you prompted? Have you, that's just another thing in your arsenal that I think is just standard that we just have to
Yeah.
be doing. Um, and it doesn't really matter how seasoned we are because sometimes your prompt might yield some information that you didn't think about, didn't see, didn't know about, just like a Google search.
Yeah. Yeah, it's the same gist.
Yeah, yeah, yeah. I think it's really important that whatever we can do to use it to make us better at what we do. That's the end. I think that's the end objective ultimately.
Yeah. 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 And now, let's say, for instance, Thomson with West, and then there's Lexis. They release an AI where you can do full memos, contracts, and everything in less time. And I'm like, yeah, sure, sign me up.
Yeah, yeah, yeah. I haven't played around with that tool, but I've been reading about it. Yeah. Have you played around with it?
Yeah.
Oh, very cool. Very cool. Yeah. Yeah. The industries. It's going to affect every industry, right? I mean, no doubt, no doubt. And so, and
Definitely.
and it's good also from the IP perspective because people are going to probably think twice now that like, oh, well, maybe I should be going out and actually formally registering my copyrights or obviously brands and if you have inventions, doing patents. So yeah,
Yeah. Yeah,
yeah.
and it's also going to force the USPTO and other offices to update their systems, which is nice, which is good for us.
Yeah, exactly. It's very antiquated, as you know, and I'm still getting comfortable with Patent Center. I I mean, it's optically I can see it's a little more slick than EFS or private pair, but it's still it's I think it's
Yeah,
funky to be honest.
yeah. I had to deal with parents when I was in the clinic for my doctor because the my thesis mentor ran the clinic, so I was like, yeah, might as well just sign up for the clinic.
Also, you did clinic.
And I helped him a lot with the design and patterns because he was like, "You don't need a STEM background for this. I'm cool with this." But I saw the whole process and I was just like traumatized. I was like, "Oh my God, how do you deal with this on a daily?"
Yeah, the trademark form, the tasks, it also looks really antiquated though, right? And but I do like the fact that the forms make it so that they create less room for error, less room for mistake.
Mhm.
It's a little more streamlined. Um, and but granted, arguably, I mean, it also is what probably gives us more assurances that will be needed.
Yeah.
Yeah, yeah. So you're also because you're also registered in New York, so you also practice in the U.S. And do you have the equivalent? Are you also barred in Puerto Rico?
No.
Okay, okay. Are you considering doing that?
I'm considering it in the long term because since we have state register both for trademarks and copyrights, that way I don't have to like ask someone else to do that for me.
Yeah, I was going to ask you about that because that's been a really interesting aspect of our practice and what we do because we oftentimes will go the state route partly because of speed.
Mhm.
Yeah,
Yeah, and you can get more stuff through the state route.
yeah, yeah, yeah. I don't know how New York State does trademarks or how efficient they are or how fast they are, but California, I mean, sometimes we see responses within a couple weeks,
Oh
2 3
wow, that's
weeks,
fast.
really fast, really fast.
Yeah, with Puerto Rico, I've seen that we receive responses like at the Like if they took their time,
A week?
a week or less.
Yeah, that's really fast.
hmm
Yeah,
Yeah, whereas with the USPTO,
nine
I
months.
registered something last year and I'm still waiting.
I mean, I've heard horror stories. Yeah, where 14 months.
hmm
It sounds like that's what you're dealing with.
Yeah, yeah.
Yeah, yeah. Last time I checked, I think their wait time I said was 9.3 months or 8.3 months, something like that, something in that time range.
Yeah, and it got worse with COVID.
Yeah, yeah, yeah. What's your favorite class to teach?
My favorite class has been Intro to IP. You know,
Mm.
this is my very biased opinion as an IP specialist, and it's because like we encourage the tangent in the classroom.
Oh, that's what I think is the best part. I mean, I think that's
Yeah,
what makes IP so interesting is that
yeah,
how it just spans every discipline and then it creates very multidimensional problems.
yeah. And like for instance, this October uh, and Halloween, we're gonna have a Halloween meets IP class.
Oh, that's really cool.
Yeah.
That's a good content topic. I have to talk to Victoria about how we might leverage Halloween in some of our content. Yeah, I really like it because you take like any business and you can easily consider how patents, both utility and design, how a trademark might impact them, how they might want to copyright some of their written materials,
Mhm.
or if they're depending on if they're a creative agency, right? I mean, they might be a lot more than just creative writing that they're copywriting, but then also some things that they want to keep secret and internal. And so, I think I like it, especially IP survey because it's so accessible to everybody, right?
Yeah,
It
yeah.
doesn't really matter, like whatever your interest is, right? There's IP considerations there, and so I think I like IP survey because it, to your point, like you're talking about food and how you could intersect the two, right? I mean, food is like a note that food has tons of opportunities for teaching
It
about
has a
IP.
ton.
Yeah.
Yeah,
So,
yeah. And it's where I also focus with my private practice. So other than being the LLM and international programs coordinator, I also have like a private solo firm, and I'm focusing on teaching IP survey because it's the only way where you can raise a concern on the general population and pique their interest, and they just want to call you and register their IP. And it's because in Puerto Rico it's still there's still a breeding ground. It's the Wild West. There's no in between pro bono and your boutique law firm. So
uh,
that's where I come in.
I see. Um, so you mean that basically people have a lot of options? Is that what you're saying in terms of?
Well, they don't have a lot of options.
I see. I see. Okay. But it creates an enormous opportunity for you, especially someone
Mhm.
who's willing to embrace all the latest technology, and is I think what makes IP cool is that it really gives people routes to be really creative, right?
Mhm.
And frankly, I think you have to be if you're really trying to maximize your client's value, the
Yeah.
value that you bring
Yeah.
to the client,
Yeah,
right?
and like for instance, any attorney can register a trademark or a copyright, but the thing is that if a client wants that specialized complete service, you're better off investing a little bit more, but not too much on an attorney that can do like the whole thing.
Absolutely.
Yeah,
Yeah.
I can do the whole thing except litigation that I leave for other experts.
Yeah. Do you find yourself gravitating more towards food agriculture for trademarks, or do you do everything? Because we our practice tends to be very varied. We do everything from, especially on the trademark side, everything from apps to restaurants to food to fashion to um, yeah, all kinds of various services, professional services. It really runs the gambit. Um,
Yeah, for now, I'm like Russian roulette with all my clients. I have really cool clients, like from the really local clothing store that is like up. up and coming, and and they're really famous on social media, to like a professional mermaid. There's a tourism website. There's a narrator from a basketball team that narrates their games.
Oh wow.
There's the inherited clients from Wipro, who are a group of beekeepers. It's very varied.
Yeah, and I tell young people, especially students, I tell them it's one of the coolest things about this particular profession is that you get to work with such broad array of industries, professionals, companies, entrepreneurs, creatives,
Hmm.
um, and and to your point, the IP survey class is so important because someone might come to your office with a thinking that they need help registering a trademark, but then they quickly learn that they also need help with IP agreements internally, with
Hmm.
copywriting photographs on their website, with possibly considering filing design patents on their products, right?
Yeah.
And that to me, I think, is what's really cool because you're always educating. Um, the other thing that personally really like about intellectual property is that you're helping people build a portfolio, so it's constructive.
Yeah.
So much of what attorneys do is tear other people down. IP is cool because really you're building. And granted, there are cases where um, litigation in particular where attorneys are even IP attorneys are doing that, but at least on the procurement side, you're actually helping build a portfolio for a client, and so you're on the same side. You have the same incentive where you're trying to maximize value, create the strongest portfolio possible,
Hmm.
and really look at it from a holistic perspective. In other
Yeah.
words, um, where does the client see itself in the industry? How do they want to be perceived? And also, where are they going? Right. So where are they investing? Because R&D, I think, really dictates a lot, at least from the patent perspective. But it also really also I think dictates their mission, right? And you get to be intimately involved as an IP attorney with all of that, with
Hmm.
at all those stages, and so it's a really special profession.
Yeah, it's really special. It's so much more than just like, oh, yeah, let's register this and go on with your day. It's like getting to know how the business works, getting to know the whole logistics behind why they chose that type of branding and voice and mission, and that helps add value to your IP. And also, like, even if you're like an IP in IP litigation, they're super friendly because they know that they are expensive,
Hmm.
and they like to litigate because it's part of like the uh, sport of litigation. But they also are like, yeah, let's just like negotiate and call it a day, and they're like really chill.
It's really cool to just to be on the ground floor. You get to work with people and clients that are working on really cutting edge things, technology, spaces, industries, um, and you're a part of their support. Basically, you're helping them build just one pillar of their business.
Yeah.
Yeah.
And you also help them like broaden their perspective on their business because so for instance, the other day I had a person who wanted a consultation for a restaurant,
Hmm.
and the restaurant was going to be located next to a pub.
Ah. Okay.
And this pub, it's like for dancing, so it's gonna play loud music and everything. And I was like, you know what? Instead of trying to fight them, join them. Do like collabs or something where you guys can both benefit.
Oh, I hope they took your advice.
Yeah.
Yeah.
Hopefully.
Oftentimes there's win-win, right?
Yeah.
Yeah. Do you also are there copyrights registerable also in Puerto Rico? I'm very limited. Okay, okay.
Yeah, but it's very, very, very antiquated. It's still done on paper by a notary.
Oh wow. Okay.
Yeah.
Is it similar to the U.S. copyright statute?
Hmm.
I see. I
Yeah,
see.
it's the same thing in Spanish, but and the difference is just the notary stuff.
I see.
Yeah.
Wow. Okay. Huh. Does that also is that a smaller percentage of your practice? Are you're mainly trademark, right?
Yeah, yeah, I'm mainly trademark. But the thing is that I've integrated copyrights because sometimes they mention, especially social media, or like they are doing side projects or side hustles, and in my mind, it's like, okay, copyright detected. Did you
Ah.
know that you have a copyright and you can, register it and commercialize it and blah blah, and there's the integration. Sometimes they just go hand in hand so much that you're like, yeah, let's just do this in like a package.
Like a package, like in other words, let's do all this together.
Yeah.
I see. I see. Huh. Do you file a lot of international marks, or is that less of your practice?
That's less of my practice. I haven't had the chance to register something through WIPO.
Okay. Okay.
I was this close to do it, but I didn't get the chance.
Yeah, it's a really useful tool. I think that a lot of clients like the idea of it, but sometimes, and especially depending on how challenging the mark is to register, it can quickly result in a lot of legal fees because you eventually need counsel in all the different jurisdictions that you filed into.
Yeah, and the international registration is expensive as it is. It's like the most basic one is like 500 francs, which is like $700, I think,
Yeah,
the conversion more or less.
it gets pricey.
Hmm.
Yeah, yeah. So US 250 or 350 per class. What is it in California, state of California? It's 75.
Hmm.
What is it? What is it in Puerto Rico?
It's 150.
Okay, okay.
Yeah. It's 150 for trademarks and 60 the same price for copyright, so it's 65.
Oh, okay.
Yeah.
Huh. That's great. They yeah, it sounds like it's a little more affordable than California or the federal. Yeah,
Yeah. And is it through the Department of State or uh,
Secretary of State.
oh, okay. Yeah, same
Yeah,
here.
yeah, yeah, yeah. It's remarkable though how efficient it is.
Yeah.
Yeah.
The only thing that I've observed is that they do tend to make mistakes every now and then.
Oh,
So you have to be like double checking ever so often. But it's like that 0.0001% chance where you're like you read the memo and you're like something's not really quite adding up in this small detail, but okay.
oh, yeah. So, what do you mean? Do you mean in terms of like how they? Oh, because you're saying they go from paper. So, oh, is it the mistake you think in transcribing from paper to?
No, when they issue like the office actions
Oh, interesting. Okay,
with like the opinions about your trademark.
okay. And so they're making mistakes on the merits.
No, it's more on like very miscellaneous issues here and there. It's very rare that it's on like the more substantive issues. It's like
Huh.
super rare, but it has happened.
Hmm. Yeah, and okay. And then do you guys also have a summer school program, or is it 2 semesters? How does your school work?
Oh, it's for the you mean for the Juris Doctor?
Oh, no, no. I was just wondering about your school, if it's semester based or
Oh, it's semester based, but we also have summer classes and
okay.
winter mini courses.
I see. Okay. And will you teach the winter and summer, or is it?
Not for now. I haven't been notified that I will teach in summer or winter.
I see. I see. Yeah. It sounds like you have a pretty good blend where you get to do academia, but then also have private practice.
Yeah, yeah, yeah.
Yeah. Keeps it interesting. There's no dull moment in what we do, fortunately.
Exactly.
Yeah. 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 Um, yeah. Do you have any questions for me?
Well, I would like to know more about your practice because it's very different. Like we studied the same thing, but it's very different. You deal with patents.
Yeah, so I would say that the trademark component is you're very familiar with, as well as copyright. The the patent side of the practice is really interesting because you're you're it's cool, right? It's a word game, right? Where you're basically trying to identify what the closest prior art is to a client's invention, and then claim as broadly as you can without stepping on the prior art. So, as you know, patents protect new and useful, non-obvious inventions, and so it's cool from our perspective because we get to see really new things, new stuff, what's coming. We get to be involved with the R&D teams at organizations. But what's really cool, I think, is that you get to work with really passionate people that are cutting edge in their field. They're experts in their field, and they educate you. So you ask them questions. How does your invention work? How is it different from this? Um, how does it operate? Why does it work like this? And so you're constantly learning. You get to learn about new technology, and then it's also cool because you get to put words on technology that others haven't put words on before. Assuming it's new and novel, you're getting to put the words on it for the first time. So that
Okay.
yeah, so that makes it really cool. It's a really fun word game. Is basically what I'm
So
trying to say.
basically, you're a walking thesaurus.
Yeah, yeah. Wikipedia is definitely a friend, and getting to learn how things operate, how things work, getting to familiarize yourself with technical language in specific art areas.
Okay.
Constantly learning. Um,
And is it mainly like all California, or is it like spread out through the US?
Yeah, so most of our clients are just happen to be in California, but there's definitely national practice. I mean, you can practice. I guess some of our clients are incorporated in Delaware. It's a really common, popular jurisdiction, as you know, to be incorporated. Um, but yeah, I'd say that it tends to be West Coast based, at least our practice.
Okay.
But with the patent bar, it's really unusual, right? You can take this exam. You have to take this exam if you want to be a patent attorney, but you can take it before law school.
Wow. Okay.
Yeah, you get a registration number. It's called a reg number, and with that reg number, you can represent inventors before the USPTO for the purposes of filing patent applications. So you can file utility and design patent applications with your reg number. So you're able to, but think about it. You can do this without ever going to law school. And what is a patent? It's a legal instrument that entitles the holder
Mhm.
to damages, assuming there's infringement. And so you, never having gone to law school, you get to craft these legal instruments that are the subject of litigation. And so I always found it fascinating that we have the patent bar, that people are able to take it without having any sort
Wow.
of legal experience. You don't have to go to law school. You don't have to take contracts, constitutional law. You don't have to take any of that.
Wow.
Yet you can sit for this exam and get a registration number and represent inventors before the USPTO.
I
Um,
didn't know this. And like for patents, you have like there's you have to go to law school because there's so much left out of context.
right, especially with I mean, because when you're drafting a claim, you're thinking about infringement and you're thinking about claim construction. You're thinking about how is a competitor going to design around this claim. You're thinking about how is some attorney on the other side going to construe this claim in a way that's favorable to their client. So you're doing a lot of legal thinking and a lot of legal work. And to your point
Yeah.
exactly,
Yeah.
it's
Yeah.
very
Like
interesting.
one of the most notorious cases that I still remember to this day from my classes, and I gave it in my class, was the Super Soaker litigation, where the whole fight was one word: they're in and they're on. That was it. And I was like, you guys got to be kidding me that this is a litigation.
And literally, the thing about the cost of that, right? Over one single word. And that's what, but that single word, right, can also determine whether or not your patent's valid, invalid, whether it's infringement, whether it's not infringement. It 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 keeps it really interesting. But you have to be really precise, to your point. And there's a lot of educating your client, trying to help them understand how to read a claim, what a claim is, and so that also in itself really just keeps it interesting.
Okay.
Yeah, I would say from the patent perspective, there's inventions that are less technically complex. Those tend to be harder to get through and allowed and through the patent office.
Hmm.
Those that are more technically complicated tend to be a little easier because they're perceived, right? It's easier for an examiner to perceive something that's more technically complex as something that should be patentable, whereas something a very simple widget, for example, may be harder for the examiner to perceive as, oh, should this really be a patent, right? It seems obvious, and so
Yeah,
uh,
and it's even harder to visualize when it's a process because like you don't see it in a picture. It's like described step by step. So it's like, what am I seeing here? Okay.
yeah, I would say also that the process overall is also really interesting. I don't know how familiar you are with it, but we do what's called an invention disclosure interview. So the inventor will describe in detail the prior art for us. So what was the problem before their invention? What were other people's solutions? How did other people address the problem? What were the other solves? What were the shortcomings? Why were those solutions not good enough? What shortcomings do they have? Um, that's generally the first part. And the second part is, what's your invention? What problem how does it solve those problems? Why is it so much better? So you might hear the term problem solution approach. That's generally how most practitioners, I would say, address invention disclosure interviews. But so we interview the inventor, get all the information that we can about the prior art, and then also about their invention. And the information that we're trying to get from the inventor is basically enough. I like to say enough to create a cookbook explanation
Okay.
for how to make and use the invention. So again, it's really the patent being a patent attorney almost feels like it's almost like teaching, right? Because you have to say you're the subject matter expert in some topic, you have to communicate it to me, and then I have to create a document that basically teaches the public how to practice that invention.
Hmm.
And so the operative quote is "pictures worth 1,000 words." I would say that's the one of the core fundamental parts of patent practice is just crafting
Yeah.
very clean and nice drawings that communicate to the public what the invention is. Not
Yeah.
just the public, specifically a judge that's trying to construe the claim. So if they're
Okay.
able to look at the drawings and the claims that you've drafted and understand the invention, that's going to make the patent, I think, more valuable because it's more easy for them to understand, and there's less room for the opposing attorney to try to construe the claim in a way that's unfavorable to the patent holder.
And if you like cooking, then it's like cooking but harder because it's words on a paper.
And so the drawings, that's the next step of the process. Basically, we prepare drawings and claims. The claims define the scope of the invention, the metes and bounds of it. Um, we try to claim as broadly as we can. So it could be a base with a first leg, second leg, third leg, right? Like a stool. I'm making it up, right? Obviously, you never write a claim on a stool. But if the prior art, let's say, no stool had ever been invented, right? It was just a stump. Well, the stump, let's just say, has one support and one base. So that would be potentially a novel claim, right? And then if you continue that hypothetical, the examiner would come back and say, well, this stump here, this would have been an obvious variation to add an extra leg to make it more stable. And then you have to, later on, after you file this patent application and the examiner issues office actions, you have to do that back and forth prosecution phase where you explain to the examiner why your stool is not obvious, why
Okay.
it wasn't an apparent variation of the stump. So, yeah, very simple example, but yeah, so claims, drawings, application. The application provides written description of the claims. It's a cookbook, basically. So someone picking up the patent should be able to make and use the invention without undue experimentation. So we prepare that application, we submit it and file it. 9 months would be insanely fast for patents. So 9 months is trademark examination. Patents, we're looking at 1.5 years, 2 years, 2.5 years. Just takes much longer.
Okay.
So, yeah.
And how did you end up with like specializing in patents? Because you did the LLM in taxes. So what was your like academic
Oh, yeah.
trajectory?
Yeah. So I actually started off. So I knew when I was an undergraduate that I was always interested in law, but I also was really interested in engineering. So in order to sit for this patent bar, you have to have a science degree. So when I graduated my undergrad, before law school, I took the exam. So I became a patent agent. I was a patent agent during my first year of law school. And I actually worked at a legal clinic doing immigration and anti-predatory lending. I worked as they mainly wanted my skills because I'm fluent in Spanish, so I could do translations. But I basically transitioned after my 1L year to a law firm. So I worked at a law firm and was able to use my patent bar exam. I was a patent agent, so I was able to do patent prosecution work. So I did that all through law school. And then even afterwards, even after I graduated, I was still working in patent law with the same firm. And then I wanted to learn more about tax. It was just something I had been interested in. And so that's why I took that route, got the LLM. And I did some interesting externships. So I got to take an externship class where I worked for the chief counsel's office of the IRS and got to work on some tax cases. And so it was a really good experience. Great. I'm grateful, very, very grateful to have had it. It hasn't been a part of my practice, but it's definitely good knowledge to have and definitely useful.
Yeah, definitely. And like a random question,
Please.
if you do these patents, do the clients give you like the prototypes and you have like a collection of trinkets? Because I remember that with my thesis clinical professor, he had like his whole office full of shelves of like the trinkets of the prototypes.
Yeah, I definitely have some random, very, very random devices. Um, Not in this office, but in another office, I have a table that a client gave me. Another office, we have this weeding device. And then I will say and this isn't really a patent specific thing, and you probably have this, but I have all these random shirts and hoodies that clothing companies and clothing clients have given me that have their logos on them.
Yeah.
So it always stays really interesting, and you get a lot of really neat little trinkets for sure.
Yeah, yeah. And my trinkets, other than like the t-shirts and stuff, I have one t-shirt that I call my trademark infringement shirt, and because it was like it was a gift from my dad, and he made it with a logo and added some additional things. So you could argue it's like transformative derivative and whatnot, but it's clearly in trademark infringement. But it's like a nice sentiment, but it's also hilarious because I studied IP.
That's funny. Do you have any parting thoughts for your audience here?
Well, I do invite you to follow me on all my socials with my last names, Zaragoza Cardenales. You can see it on, oh, that's nice.
Oh yeah, oh yeah.
Oh
The
wow,
high
I
tech
feel like it. I feel like an anchor woman about to give the news.
word.
I'm on Facebook, Instagram, TikTok, and now I'm on Spotify and YouTube with my podcast. And that's where I talk about tangential stuff like business, leadership,
Awesome.
food, travel.
How do we find your podcast?
It's with my last names on Spotify
Okay.
and YouTube.
All right, I'm gonna check it out right now. Thank
Please, I need subscribers.
you. We
And
can
where can people find you?
Instagram, TikTok, on Facebook, YouTube. Our YouTube channel is actually a really, really good avenue. We put a lot of informational videos on our YouTube. And Victoria, am I missing any other channels? Yeah, those are the core. Those are the core. We also have a link tree that has our more recent content. It also goes up on Facebook, YouTube, Instagram, and TikTok.
Yeah. And you can find my videos in both languages, in English and
Really?
Spanish.
How do you
Yeah.
do that?
I film everything twice.
Oh my gosh,
Yeah.
that's amazing. Victoria, let's start doing that. We'll create some content in Spanish too. Hit the LATAM market. Wonderful. Yeah, so that's our social tag at EVIP group. Well, thank you so much, Paola. I really, really appreciate your time. Thanks for talking to us. Thanks for doing this. I hope we get to do another live stream. We can.
Yeah, definitely. Thank you so much for giving me the time. I hope that one day we can meet in person.
Yeah, I can't wait. Yeah, I'm yet to go to Puerto Rico, so I'd love to visit. I don't know if you're ever in the Bay Area, but you're always welcome to visit our office or just meet up wherever. Wonderful. Well, thank you.
Thank you.